Welcome back. Today we're diving into the high-stakes world of Bexar County probation hearings, where a single phone call, or the lack of one, can cost you 20 years of your life. We got a defendant who skipped town for a healing mass while owing a small fortune in restitution, and a second case featuring a presidential relative that has a judge reaching for the gavel. Let's see who's actually telling the truth and who's just digging a deeper hole.
Phone's not work. Does she have access to a phone?
I believe she does, Your Honor.
Why didn't she pick up the phone and call probation and say, hey, may I depart Bexar County to go? Okay, why are you not reporting?
Well, on when I got arrested, I received a text.
You smell of alcohol, I'm told, Ms. Hinkle. Are you
I
drunk?
was drinking last night.
Are you drunk?
No.
We're going to give you a PBT, okay? You're drunk.
No, sir.
You got a .166 on the PBT.
You getting your life in order, maybe, finally. But here's the problem. Your history is awful. It appears that you're not learning anything from your...
The deadly weapon after police say that she stabbed her boyfriend with an 8-inch kitchen knife. It happened last night in the 200 block of Greenlawn just before 10:30. The boyfriend taken to University Hospital in critical condition. Padilla was arrested right at the scene.
Hello. How are you doing this morning? You're whispering. All right. So the reason why you need to be extended is because you have restitution that you need to pay. And I understand that there are issues for you, that you have other bills to pay. But in the big scheme of things, you're on a criminal probation and there's restitution that's related to the criminal act that you committed. So that those people need to be paid. So I understand you're behind on your mortgage, your electricity, and your water, but people have to be paid. You understand? Do you have children?
Yes, they're already older.
All right. So I don't know if it's possible for you, but you may need to get a second job because you have to pay this restitution. And you were on probation for 5 years and extended for 3 years. I can extend you up to 2 years. Do you understand?
Yes.
So probation is going to go over with you and try to get an idea of how much you can pay per month. So you need to be thinking about how much money you can pay per month. And you're going to have to start paying that per month because restitution needs to be paid. You understand?
Yes.
Probation, is there anything else?
It looks like she's been in compliance with everything else. She's done all of the programs that you've set forth and everything. It's just the restitution.
Okay. All right. Thank you for coming down. Have you all conferred with probation?
We have, Your Honor. Yeah.
Okay. Are you all ready to proceed?
We are, Your Honor.
All right. Court is calling 2015 CR 3473, State of Texas versus Rose Padilla. Can I have parties announced for the record for the state?
Wilkins for the state, Your Honor.
Defense?
Sorry, Judge.
All right. For the
We'd like to
state?
work together, Your Honor. This will be Zach Dunn for the state.
Shannon Locke for Rose Padilla.
All right. And are you Rose Padilla?
Yes.
All right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rose Padilla who's placed on deferred adjudication and cause number 2015 CR 3473 for the offense of aggravated assault with a deadly weapon on September 9th, 2015 for a period of 5 years and extended for a total of 4? Is that you?
Yes, ma'am.
All right, state.
Your Honor, on or about the 30th day of September 2023 in Bexar County, Texas, the defendant, Rose Padilla, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
Yes. True.
State.
Your Honor, the state waives and abandons the other condition.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Okay, I'm gonna need you to speak up so the court reporter can hear.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes, ma'am.
Court will find violation of condition number 7 true. Is there a proposed agreement?
There is, Your Honor.
And what are you all proposing that the court follow?
The proposal, Your Honor, was to continue on probation, extend for 1 year, and amend for probationer to pay at least $100 every 2 weeks for restitution.
Your Honor, the original recommendation was for revocation. However, it does indicate that if the court wishes to continue to extend the 1 year, amend the probationer to pay at least $100 every 2 weeks for restitution.
How much is owed on restitution?
Your Honor, $78,775.98.
How much has she paid on restitution since she's been on since 2015?
$2,360.
Your Honor, Ms. Padilla is a waitress. She used to be a waitress at Christian's on San Pedro. She works a lot, constantly. And she is frankly incapable of making any other payments aside from the ones that are recommended.
Hold on, let's do the math. She owes nearly $79,000 and has paid back about 3% in 8 years? In the legal world, restitution isn't just a suggestion. It's a condition of her freedom. The judge is skeptical, and rightfully so. If you were the victim waiting for that $78,000, how would you feel about a $100 every 2 weeks payment plan? Drop a comment below. Is this a fair deal or a slap in the face?
$100 every 2 weeks.
All right, why is she leaving the county without permission?
So she was, there's a healing mass that occurs in Hidalgo County on the last Saturday of every month. That's where she went. She felt called to go there. It's something that she's had a significant benefit from in the past. And so she'd heard about this mass and decided to attend that mass with her significant other.
All right, do phones not work? Does she have access to a phone?
I believe she does, Your Honor.
Why didn't she pick up the phone and call probation and say, hey, may I depart Bexar County to go for this? Because honestly, she hasn't been doing well on probation. I mean, that's why we're here. Probation is telling me they want a revocation. And in this court, normally it takes some doing for me to grant a revocation. So for probation to be asking for revocation when they know that normally if there is monetary issue, if there is a drug issue, usually I try to address those before we head down the road of revocation. So for them to be asking for revocation, that says something. So why didn't you pick up the phone and call probation and ask them if you could leave Bexar County to go to this event? You want to raise your right hand for me? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Rose Padilla.
All right, why didn't you call probation?
It wasn't a Saturday and I thought, nothing was gonna happen. Just me going and coming back.
You cannot leave Bexar County without permission while you're on probation. You understand?
Yes, ma'am.
Now, they want you to pay $100. What did you say? Every 2 weeks or how often? Every 2 weeks?
Yes, Judge.
Are you able to pay this $100 every 2 weeks, or you're just saying that?
No.
Because let me just tell you why I'm asking that question. I find that when people are looking at potentially going to prison for 20 years, if people say, all right, we will agree to continue if you pay $500.
The judge is calling out a classic courtroom phenomenon, the desperation promise. When prison is on the table, defendants will agree to almost any financial terms just to walk out the front door. But the court knows that if the math doesn't add up, she'll be right back in this chair in 3 months for a motion to revoke. Judge Boyd is trying to save her from her own empty promises here.
$100 a week, you know what people will say? Well, I'm going to call this person and I'll pay $500 a week. So I want to know, can you really pay $100 every 2 weeks? Or are you just saying this because that's the agreement you all reached? Or will you be able to pay it? If you're not going to be able to pay it, you need to let me know now, because if I follow this agreement and I get a report that you miss one of the weeks in paying, we're gonna have problems. So if you cannot really pay $100 every 2 weeks, you need to let the court know now.
Now I'm trying to get back on my feet and I think, but if I have a problem or something, like I have health issues, I mean, can I call and let y'all know that, I mean,
No, see, here's the thing. Your agreement that you all have made, regardless of what health issues you have, is that you're going to pay $100 every 2 weeks because there's somebody out there, and I'm not the one who took this plea because this was before my time, but there's somebody out there that you owe $78,000 to. So you agreed and your attorney agreed that you are paying $100 every 2 weeks. So there is no, well, maybe something may come up. You've agreed that you would pay $100 every 2 weeks. That's why I'm asking this. If you are telling the court, actually, I'm not going to be able to pay $100 every 2 weeks. I was saying that, hoping that I would be able to do it because this is the only way where maybe the state would agree not to revoke. I don't know. I'm not a part of your negotiations. But if that's the fact, you probably need to step back and talk to your attorney and you all actually come up with a reasonable amount that you are going to be paying, no questions asked. And it should be amount that you should pay, not depending on this person giving you money or that person giving you money, because we're going to be right back here because they're going to file a motion to revoke if you miss any of those payments. So do y'all want to step back and discuss that, or y'all want to continue with she's going to be able to pay $100 every 2 weeks?
$100 every 2 weeks.
All right. So you're saying, and you're telling the court, you're telling probation that you're going to pay $100 every 2 weeks.
Yes, ma'am.
And when is this going to start?
And it started in 2 weeks, Your Honor.
When's her next pay period?
What's your next pay?
Maybe next paycheck, I get paid every Wednesday.
All right. So this is her first payment, then is going to be, since you get paid Wednesday, is that electronic deposit maybe or no? All right. So her first payment, she's going to be making payments on December 7th. That should be her first payment of beginning every 2 weeks. Do you understand?
Yes, ma'am.
And since she gets paid on Wednesday, her payments should be falling on that Thursday because she has to get the check, go cash the check, and do all of that. All right. I'll deny the motion. Alternate amend conditions to include $100 payment every 2 weeks, beginning on December 7th. And that's to go towards restitution. Is there anything else from either side?
Nothing from the state, Your Honor.
Nothing further, Your Honor.
Probation, is there anything else?
Yes, Your Honor. Her case expired September of this year, so that 1 year extension, are you going to move forward with that?
Yes, extend for 1 year.
I would also like to bring up to the court that we have notification that Ms. Padilla has not reported since September. So I would ask that the court admonish her and ask her, tell her to report as necessary.
Okay, why are you not reporting?
Well, on when I got arrested, I received a text and then I got a warrant and then I went to go talk because they told me I needed to get an attorney or for my bond. So when I went go talk to him, and then I have the text where my probation officer text me that I had an appointment yesterday, which I went in yesterday, and she even sent me for a UA for tomorrow. And I go, why wait for tomorrow? So I went yesterday to go get a UA too.
All right, here's the thing. Don't miss reporting. You understand?
No, ma'am.
All right. So I'm assuming you're required to report monthly. When do you want her to show up to report?
I'll look at the appointment book to see if it's already been put on the books. For
All right. So she's going to give you a date when you to report, and you need to report. Don't miss any reporting dates. Here's the thing. Sometimes miscommunications happen. I've already said that I'm going to continue you. So there's no need to for us to go back and forth. As
Yes.
my grandmother would say, who shot John? Here's the thing. She is going to give you a date for when you report. You need to make sure you report on that date. Even if you're saying you've already reported, if she gives you a different date, you need to go report on that day. If you do not, what will end up happening is a motion to revoke will be filed. Do you understand?
Yes.
All right. And then I saw in the motion to revoke this new number 1 that nobody's going on. What is happening with that?
So, Your Honor, one that is out of county. The investigation that I've done, I don't believe it was more serious than a Class C misdemeanor. So I don't expect anything to come up. We'll certainly keep an eye on.
All right. And is there any issue with her and UA?
Your Honor, in August, it says it was failure to submit. In September, it was a negative. I don't have anything past September because there was that lapse in reporting. So if she said she UA'd yesterday, those results will not be available until next week.
All right. Did you UA yesterday?
I went yesterday, yes.
All right. Make sure she UA yesterday. If she did not UA yesterday, then we're going to have a problem because people are being dishonest with the court. So if you UA yesterday, she's going to check it. And then from thereafter, do random UAs.
Yes, Judge.
All right. Is there anything else?
Nothing further, Your Honor.
Is there anything you need from the court to be successful on this probation? All right. Do not leave Bear County without permission. Because you're on probation, everything you do, you need to pick up the phone and call probation and request it.
Okay.
Could you waive the UA fees, Your Honor? Is that possible?
No. Okay.
Thank you, Your Honor.
All right. Thank you. Oh, did y'all complete the certification of defendant's rights?
I'm doing it right now, Judge.
All right. Thank you. All right. The court is calling 2015 CR 3473 State versus Rose Padilla. Could I have parties announced for the record? For the state? For the defense?
Robert Valdez for the defense.
And are you Miss Padilla? You need to, okay, everybody is whispering. Why is everybody whispering? You need to speak up so the court can hear.
Yes.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rose Padilla who's placed on deferred adjudication for the offense of aggravated assault with a deadly weapon on September 9th, 2015 for a period of 5 years and extended for a total of 5 years? Is that you?
Yes, ma'am.
All right, state.
Judge, if I can have just
Violation of condition number 10 in Bear County, Texas. Between the date the defendant Rose Padilla was placed on community supervision and the date of filing hereof for restitution, the defendant should have remitted $81,135.98, but has only remitted $2,504 in violation of condition number 10.
How do you plead to that? True or not true?
Not true.
Violation of condition number 21, on or about the 17th day of June 2025 in Bear County, Texas, the defendant Rose Padilla did then and there fail to complete GED as instructed by the court in violation of condition number 21.
How do you plead to that?
Not true.
And violation of condition number 23 in Bear County, Texas, the defendant Rose Padilla did then and there fail to make payments of $100 every 2 weeks in violation of condition number 23.
How do you plead to that? True or not true?
Not true.
All right. Will you all be ready to proceed on a contested hearing the second or third week in January?
Judge, you said the second week of January.
Second or third week.
Yes.
All right. Oh, we can bring it. No, I'll do it. It's fine. All right, what date?
It would be the 12th.
But it is a simple case. Okay, we'll just do it on the 12th. Unless somebody wants to do it now and have the probation officer zoom in.
Judge, the officer.
All right, we can do the contested hearing now. They'll have an officer zoom in. Everybody just have a seat. Are you Rose Padilla? All right. My understanding is that you wish to change your plea to true on one of the allegations? You need to speak up. All right, state if you'll read the allegation.
Yes, Your Honor, apologize for 1 moment. Violation of condition number 23 in Bexar County, Texas. The defendant, Rose Padilla, did then and there fail to make payments of $100 every 2 weeks in violation of condition number 23.
How you plead to that, true or not true? All right, did you understand by pleading true to violation of condition number 23, the court could find it true, grant the motion, sentence you to 20 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 23? Court will find violation of condition number 23 true. What is the state requesting?
Your Honor, along with probation's recommendation, the state is requesting that the court grant the motion to enter adjudication of guilt, revoke the defendant, and place her on probation or community supervision for 10 years.
Well, no, is this an aggravated assault with a deadly weapon? Or is this, I think this is aggravated assault with a
Let
deadly
me
weapon.
check and see
So-
what led to. I apologize. Can you step back for a moment?
Sure, so yeah. All right, sure, her plea of not true will stand for violations 10, 21, and 23. And you all come back here for a contested hearing.
When do we come back?
Norma, when can we fit them in for a contested hearing?
I can do the January 7th.
All right, January 7th will be your contested hearing.
Thank you, Judge.
Thank you.
Judge, I'm sorry.
January 6th, 2026. The record shows this case returned to court for a contested motion to revoke. This kind of hearing isn't a new trial on the original charge. It's the court looking at supervision rules and deciding whether the second chance status stays in place or whether it gets converted into a conviction and sentence. At the hearing, the defendant pled not true to the alleged violations listed as number 10, number 21, and number 23. That means she did not admit the violations, and the state would have to prove them. The court setting was under Stephanie Boyd's court, and the record also notes a visiting judge, Raymond Angelini, handled it that day. The key result in the record is straightforward. The court denied the motion to enter adjudication and continued her on probation. In other words, the court did not revoke her deferred status at that hearing. Then the next day, the record shows the bond was closed, which is typically the paperwork side of wrapping up the custody/bond status tied to that court event.
Indeed. Your name?
What?
You smell of alcohol until Miss Hinkle. Are you drunk?
was drinking last night.
Are you drunk?
No.
We're gonna give you a PBT, okay? My court officer is going to administer a PBT to you.
I
So,
was drinking until.
ma'am,
Go ahead and leave the hallway.
we're gonna administer a PBT to you.
Go ahead and see the hallway.
And you'll go out and, so that goes to the prosecutor. That's the PBT. People against Labadie. Reed Dean Labadie Jr.
Yes, sir.
You're drunk.
No, sir. I still.
You said no, sir. What's your name? Tell me your name.
My name is Lori Gainville.
You got a .166 on the PBT.
I was drinking until 4:00 and I didn't. I did. Now that I couldn't believe that was.
You're still drunk.
No, it was.
Yeah, you got a .166. Who drove here?
My friend.
Who's- Is this the guy here? Did he drive?
Sir Raymond,
Slow down.
cousin.
What? Hang on a second.
Well, the 11th cousin to the United States President.
What's his name?
Sir Ronald Raymond Hamilton. The cousin to the president. Yeah.
The president of the United.
Wait, did he really just pull the 11th cousin to the president card? We've seen a lot of excuses in this courtroom, but name dropping the commander-in-chief to get out of a .166 PBE is a bold strategy. Spoiler alert, the law doesn't care about your family tree when you show up to court intoxicated. Check out the guy's face in the background. Even he isn't buying it.
States,
Yes, sir.
the president right now,
Yes, sir.
he's shaking his head no. Why is he shaking his head no? If he's not the president, why you
No, it's not president. It's the 11th cousin.
11th cousin? He's shaking his head no. And he's not the 11th cousin. And honestly, I don't care if he's the brother of the president. It's not going to help you, so I don't need to hear this. What I do want you to know, if you show up for court again drunk, we're going to have a big problem. I'm going to reschedule your case. Sir, you cannot let her drive. Do you understand?
Thank you, Judge. You know,
Well, you got it.
pledge allegiance.
I'm sorry?
Pledge allegiance.
Pledge allegiance? Is that what you said?
Yes. I'm not justifying.
Just relax. Heather, give me another date, will you please? I should probably have you locked up until you go down. Give me another date.
We can do February 18th at 9:45.
Come on up here, sir. What is your name?
My name is Ron Pennington.
Did you drive her here?
Yes, I didn't. No, the alcohol when she got up.
You live with her?
She stayed with me that night. She had these 2 days off. I come with me. Early afternoon. She's up in the house when she got.
Is she gonna have access to a motor vehicle?
No. Not that bad.
Do you own a motor vehicle, ma'am?
That's what
Does she?
a 27 Ford Focus.
She owns it.
Light gray.
Well, hang on a second. You just told me she didn't have access. If she owns a motor vehicle, how does she not have access to the vehicle?
I'm the one when you. I picked him last night.
Go down the home, get your new date. It's going to be February 18th
February 18th.
at 9:45 in the morning.
You can 45 minimum. No alcohol.
Don't show up drunk. Don't show up after consuming alcohol.
Okay, sir.
I understand.
Okay.
Sir, I'm gonna let her go. I'm gonna trust you're not gonna give her those keys.
Thank you. I'm trying to put it, get it into a treatment center for alcoholism.
All right, let's not have any further discussions here, okay?
Okay.
That's what I'm gonna do. Do not drive. Do you understand?
Yes,
Do not drive. You understand?
yes,
Sir.
Go down the hall. They'll give you a notice. Thank you.
I was like, I don't remember hearing the motion on this. You didn't. Okay. So Brenna, my mind is still a steel trap.
Mine's been sprung.
All right, court is calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. Go ahead, parties announced for the record for the state.
Ryan Grimmer for the state of Texas.
For the
Robert
defendant.
Maurer for defendant.
And are you Ms. Yepes?
Yes,
Ms. Yepes, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Yepes, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We're not, Judge. There's 2 counts in there, Judge. We proceed on count 2, and we would waive the enhancement allegations. We would also waive count 1. Count 2 is a second-degree felony, straight possession, 4 to 200 grams.
Any objection?
No, Your Honor.
Ms. Yepes, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on count 2? And that charge is possession of controlled substance, felony group 1 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have all right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, so we're going to come back on July 25th at 9 a.m. for sentencing. Ms. Yepes, the court will make its decision on your application based upon a report I received from probation and any other evidence that is presented to me on that date. Do you understand?
Yes, ma'am.
Mr. Mauer, is there a need for a TAP evaluation?
I'd ask them to be done, Judge.
And Rebecca, there's going to be a TAP evaluation.
Yes, ma'am.
All right, the probation officer is here and back. She'll go over everything that needs to be done, but do not leave before you get a reset form.
Yes, ma'am.
All right, if there's nothing else.
Not on this case, Judge. I would like to approach another case.
All right, thank you.
And that is a wrap on a chaotic day in Bexar County. From $78,000 debts to presidential cousins, it's a reminder that the court sees everything eventually. Padilla gets a 1-year extension to prove she can handle her restitution. But the clock is ticking. What do you think? Will she make those $100 payments, or will we see her back here for a revocation? Hit that subscribe button for the next breakdown, and I'll see you in the next one.
In the afternoon. The court is calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. That party is announced for the record for the state.
Marcus Sanders.
For the defense.
Robert Mauer for defendant.
Are you Ms. Yepes? All right, you entered a plea on May 9th to count 2. You entered a plea of no contest. The state waived the enhancement and count 1 without objection. According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine, and the state opposes your application. Have both parties had a chance to review the PSI report, state?
Not yet, but I'm working on it. Judge, I've reviewed the PSI. It's pretty straightforward. The state was opposed based upon, I think, the criminal history and the amount of drugs.
All right, so are both parties ready to proceed, state?
I'm ready.
Defense? All right, state, you are opposed.
Yes, Judge, we are.
Do you have any witnesses?
No, Judge.
All right, defense, do you have any witnesses?
Judge, no, I'm just arguing on behalf of my.
All right, the court will hear argument, state.
Judge, that's correct what defense counsel said. Our opposition is based mainly on this defendant's criminal history. Looking at the PSI, it looks like she's been given a chance at probation at least twice before. It looks like in 2005, she was granted probation for 10 years on a felony in possession. And she ended up being revoked. And actually in 1993, she was given deferred and then placed on probation and got revoked. So that's twice that she's been given a chance. It looks like we played the offense down just to give her a little bit of benefit for accepting responsibility for her actions. But that's why we don't believe probation would be appropriate in this case. We're asking for prison sentence.
All right, defense.
Judge, we understand fully why the state made the recommendation they did. Ms. Yepes asked me to speak on her behalf because I think she's kind of nervous speaking in public. Since her release on this case, Ms. Yepes, I think, has made significant strides in turning her life around. She finally got a job at Mood Solutions. She's been made a supervisor. She makes $15 an hour. I think this is probably the best job and the best situation she's found herself in. I guess for a number of years, I think she's really got her situation solidified, and I think she would benefit from the opportunity for probation with whatever terms of what was appropriate. That's obviously the most important thing. And we'd like the court to consider that and consider one, I think, remorse of finding herself in the same situation again. I think TAP talks about issues that have been on again, off again with drugs in her life. You would ask the court, if the court does see fit to give her probation to allow her to do intensive outpatient. She's very concerned about keeping this job that she was finally to get. I think it's very difficult for people with Elizabeth's criminal history to find jobs in in the workforce. And I think this company is willing to work with her. And I think it's put her in a situation where she can be a successful part of society. So that's the court to grant.
All right, so the court has a understand. I don't know if there's anything that I can do for you because you have not learned anything.
Last time I've learned a lot. I haven't worked in my life like I've worked now. I've been working for almost 3 years now. I was given a chance to get a position as a supervisor's responsibilities that I have to do. Something I haven't done in many years. So it's yes. I feel like I've worked for and I want to continue to keep it. If I lose it all, then I feel like I can age and I lose my history. My background is not ever going to change. I won't be able to. I won't make it like that.
Right. And here's, I'm sympathetic to what you're telling me. I'm sympathetic to you getting your life in order, maybe finally. But here's the problem. The amount of drugs was a lot. And your history is awful. All right. This is what I'm going to do. I'm going to find her guilty as previously stated. I'm going to sentence you to 4 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right. And we're off the record. Ms. Yepes, I actually gave you less than what you bargained for because I did consider the fact that you did come in with employment. You understand? Do not come out and do this again because you don't know who your attorney is going to be. You don't know who the prosecutor is going to be or who the judge is going to be. And you will be a habitual in your minimum.
Go ahead, state.
Yeah, I would like to open Judge focuses on girls. This indictment started in August of 2021, but it detailed conduct whenever they were so young they can hardly remember their details.
It started when? You said 21.
The indictment was returned on August 25th, 2021. And it took till December 17th, 2025 for any acknowledgement about the wrongdoing in this matter. And all kinds of things can be said, but this family is so frustrated with how long it took to get to a point where this man would stand before somebody and accept responsibility for his actions. The defense, but the manner in which they detail the procedural history on this, I find offensive. They claim it's a one-time incident and really just try to minimize what's happened here. There's several incorrect statements within the motion suggesting to the court that you can only sentence him to 8 years when our cap is 10 years. They do state in their motion that in order for the court to grant probation in this matter, that there has to be a finding that it's in the best interest of the children. And not one single argument is suggesting as how it could possibly be in their best interest. Then they attach countless numbers of letters from family, friends and family of Mr. Tyler that sans one letter from an attorney says he's not familiar with the specific facts surrounding the incident. Nobody acknowledges these children and what they went through. It's all about Mr. Tyler. The detail within the PSI talks about the frequency And specifically, one child talks about how this happened over 100 times. And I wait to hear how we have any true acceptance of responsibility when we look at page 2, where, quote, the defendant further stated, "No, I do not take responsibility for this offense." Basically minimizing again, talking about how it just tickles them. That he's an elderly Vietnam War veteran. However, the defendant is denied full responsibility for this offense and minimizes his conduct. The defendant presents a significant risk to minor children due to multiple familial victims over an extended period, intrafamilial access and position of trust, repeated sexual contact, including groping. And we knew that they would come in here and make a presentation for probation. What other option do they really have? But it's not in their best interest. And in our opinion, it does not do justice to what's happened here.
Judge, I think Mr. Tyler has really struggled to come to grips with what he has done and what the impact that it's had on his family, it essentially has torn his family in half. And he recognizes that. One of the things I would point out that was not included in the pre-sentence report, Judge, was in his pre-sentence interview paperwork. It's flagged right there at the top. Do you have a copy of this?
No, sir.
I can give a copy, Judge. Yeah, it's just one word, Judge. It's asked, how does he feel about the crimes he's committed? And he says, remorseful. And he wrote that unprompted. He wrote that without talking to the probation officer or anything else. But my concern is, and I'm not being critical of probation, they have a very difficult job in doing these interviews and coming up with these assessments. But it's frustrating to me that that is the word that he used, and yet that word was not included at all in the pre-sentence report. And instead, that the family has felt.
There's still nothing that's been said about that. I too read every one of those letters that were attached about this man. And I walk away with it with a different opinion. He has groomed all those people, just like he went through the grooming process to do this with these children. It is his conduct that we are here talking about. We don't excuse people's behavior because one day they were great and the next day they murder somebody. I use that analogy because it is only through his conduct that there's a division in this family. I was in tears talking to his son this morning about what he has to do with the fact that he can't even talk to his dad anymore. This grandfather has forever changed those children. Forever. And their frustration at the fact that it took so many trial dockets, so many times that this thing got reset, for him to come along and finally accept some responsibility. It's like I said, it's a horrible journey that really none of these folks should have ever experienced. But here we are. Here we are where Mr. Tyler is asking for probation. One thing of note, Judge, is throughout all the numerous trial dockets that we've had, there was one witness that stuck with me as to why it is that he was so willing to come and testify. And that was Jeremy Bradshaw. That was the pastor over where Mr. Tyler went to church. And it was at that church that everything came out and it was told. And there was a confrontation between Mr. Bradshaw and Mr. Tyler that led to his admissions. As even then, it was only partial because of the shame that went on, because so many people believe all those things that are detailed in the letter. But this man, who now lives in Nebraska and has been living from such a great distance, has been willing to come down and testify at every setting. And I repeat that because I lost count at the number of times I had to marshal or other lawyers marshaled up witnesses to come to court and get this case tried. But that stands out. It makes sense that others that are so personally involved would do it, but it really underscores the true character of not only the witness, but the reality that the shamefaced situation that was there when a church member comes forward to talk about in detail what he was doing with his grandchildren. Two strong young ladies have stood forth, and they are asking Your Honor to assess a punishment of 10 years, and I join in their request.
All right. Mr. Tyler, anything you want to add at this time?
I take responsibility for my actions, Your Honor.
What did you do that you're responsible for?
I love my kids. Okay.
That's not a crime, sir. What did you do that caused you to be here looking at prison time and being indicted? Because here's the problem. I'm looking at this pre-sentence report here, and during the pre-sentence investigation, you stated, I do not take responsibility for the offense. I tickled the male grandchildren, and the female grandchildren wanted to be tickled too. It was just grandchildren. That's what you said you're responsible for. How does that work with you pleading guilty to me under oath, stating you committed these offenses and you swore to God that was true? This is a completely different story. Which is the truth? Do you accept responsibility or not?
I do have responsibility for my actions.
Which were what?
What the court indicated, Your Honor.
Abusing the children?
Yes, sir.
Okay. Oh. Anything else you would like to add, sir? Can you explain why?
No, Your Honor.
No. The court has had its experience in law. I've been a lawyer for 40 years, over 40 years, and I've handled and been involved in the middle of the worst capital murder case maybe in the United States' history with James Byrd. And that haunts me to this day, dealing with what happened there. But no less painful to deal with is the harm to children. I have 2 children. I have 3 grandchildren. And I can't imagine harming them in any way. I can't even imagine that. I think that's maybe the worst thing that could be imaginable. But what happens here in this situation that I'm reading, sir? And I don't see any history of wrongdoing here until this comes about. And there's nothing that this court is shown here in this pre-sentence report that has some kind of legal reason that is defensible. This shows nothing but you had a choice to make, and you made a conscious choice to abuse the grandchildren. And dealing with murders and the harm to the children, this court, I don't know how you can really weigh those two because it's apples and oranges. But I can tell you that the greatest blessing that our Creator gave us with children is the fact that we can enjoy their innocence. And when that is taken away, as I read this court finds it hard to believe a more harmful event can occur. What is the price for the loss of innocence of a child? You can't place a figure on it because it's forever. And you just hope that they can rebound somehow and live their life without those haunting memories of their grandfather abusing them, which lasts forever. What kind of punishment is fair for a child that is harmed forever? It seems like it should be severe. And I just think family is special. And I'm looking over there and I see some to the left and some to the right, and then there's a vacant middle. There's a family separated. So this is a multi-dimensional harm that I hope somehow the family, because families, we didn't get to choose them. Our Creator gave them. Our Creator made the master plan of how our family would be put together. Not, we don't get to choose. It's our Creator. I know there's a good purpose for all that. But this hopefully will be somehow resolved for them. And for you, what's difficult is for an 81-year-old person to be sentenced for such a serious crime. That works against all of us feeling that people who are elderly, we got to be very careful of punishment. Yeah. But there's nothing in this report that shows that you had a disability or infirmity or mental illness that caused that prevented you from making decisions that you elected to make. And those choices have consequences, no matter what our age.
Can I say something?
Sure. This is an important time.
Regardless of what the outcome of this is, I still love my family, my grandchildren. That will never change.
But those are words.
Yes,
but
things.
You didn't act out of love in harming those children. And actions speak far more louder than words. I sense you deeply regret what has happened. I just wished I could have been next to you before you made that choice, and to whisper in your ear, do not make this choice. This is a forever mistake that will harm the people you claim you love.
Yes.
Forever. This is one of those where people say heads I lose, tails they win. It's a no-win situation for anyone. But that's why the law came into being, so that we can resolve problems and mistakes. This is obviously a terrible, tragic mistake that all of us think of as a nightmare. In each of these cases, sir, with nothing further, each of these cases, these second-degree felonies of indecency with a child by sexual contact, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. And that it's my clear understanding from the state's presentation, correct me if I'm wrong, that the victims and their families have requested that the defendant be punished.
Yes, sir.
In this case,
it is their specific request for the 10-year sentence, Judge.
Right. Victims have a voice with this court. They always have. Sometimes their voice is made for reasons of emotion, and sometimes it's made because of not only it's fair, but it has broken the hearts. And once again, because the court has not seen anything in this report that shows that Mr. Tyler was incompetent to act responsibly, I find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements. And you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each of these cases, which shall run concurrently. It's a terrible set of circumstances. And again, the court is basing its decision on what do we value the innocence of children on. And in the United States of America, it's of highest interest. I just wish I had the power to change history. We move forward, and this decision is what the court deems as justice under these circumstances. Anything else to add?